Good day, ladies and gentlemen. Thank you for standing by, and welcome to today's presentation on the EU-US Privacy Shield and the future for U.S. data transfers. Your first speaker today is Sally Anaro, Senior Data Protection Advisor. I would now like to turn the conference over to Ms. Anaro.
Thank you. Hello, everyone. This is Sally Anaro from Taylor Wessing, and welcome to our webinar. Today's webinar is part of our webinar program, where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, and these have included issues like managing cybersecurity risks, employment practices, big data, the use of CCTV, and of course, we've been tracking the progress of the EU data protection regulation, among many other subjects. Recordings of those webinars are still available if you've missed them and wish to engage on any of those topics. Today we're going to be looking at the EU-US Privacy Shield, which was announced by the European Commission at the end of last month as a replacement for the safe harbour regime for international transfers of personal data to the USA. But before we get to that, for those of you who are new to Taylor Wessing or new to our webinar program, welcome. And as you'll see from this slide, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets. We provide a full-service law firm offering from our office footprint that spans across Northern, Central, Eastern Europe, the Middle East, and Asia. And we've listed more details about the firm on the slide deck for your reference. Today's webinar is brought to you by our International Data Protection Practice. Now, our team advises on all aspects of data protection and information law from our office footprint. And we're a global 22 partner-driven team, and we're also complemented by our international network of data privacy law specialists. At Taylor Wessing, we have a dedicated microsite specifically for all things data protection, which is called our Global Data Hub. And from this site, you'll be able to access news and weekly updates and a bi-monthly mail shot if you register. We also take a regular look at developments that are raising concerns, issues or challenges and other topical issues. And you can also access details of our forthcoming webinars, along with recordings of our previous archived webinars. As I mentioned, my name is Sally Anaro, and I'm a senior member of the London Data Protection Practice. And today we have several members of the data protection team joining me. And their profile information is on these slides for your information. So, as I mentioned, in today's webinar, we will be looking at the European-US Privacy Shield. The dramatic Court of Justice decision in October 2015 that declared the Commission decision underpinning the safe harbour scheme to be invalid had the effect of throwing regulators and businesses alike into a bit of a tailspin. Safe harbour had been seen as a straightforward mechanism to allow for the flow of personal data from the EU and was particularly attractive to US organisations looking to avoid having to sort of repeatedly enter into multiple model contract clauses over and over again with each of their European customers. Over the 16-year life of Safe Harbour, thousands of US businesses have self-certified their protection for the data of European citizens, and the legal protections that it claimed to provide meant that it underpinned a very large number of the commercial intragroup operations as well as commercial services that involved the flow of personal data out of Europe. Now, the Court of Justice decision resulted, as we probably are all aware, in a torrid few months of indecision and frantic activity to implement alternative transfer solutions within organisations that had perhaps previously relied on their own or on a vendor's safe harbour certification. So the Commission's announcement last month of a form of agreement for an EU-US Privacy Shield to serve as a replacement for Safe Harbour, as well as the publication of a draft finding of adequacy has therefore been greeted with cautious optimism by businesses, although albeit perhaps possibly slightly less optimistic caution by the data protection regulators. So in today's webinar, we're going to be discussing these latest developments and looking in particular at the terms of the Privacy Shield and what comfort it really brings. We'll also look at what the regulators think and their attitude to enforcement, pending a final decision being made on the draft finding of adequacy for the Privacy Shield proposal. However, it's worth also remembering that there are still other adequacy mechanisms in place which for now remain valid, not just for EU-US transfers, but for any third country transfers out of the EEA. And we'll take a slightly more detailed look at these alternative valid transfer mechanisms, or the key ones, in the form of model contract clauses and binding corporate rules. And we'll cast our eyes ahead in terms of what to expect over the coming months. So without further ado, I will pass over to my colleague, Debbie Taylor.
Thanks, Sally. It can feel as though we've been talking about data exports for a very long time now, but it has, as Sally said, actually only been a few months since the CJU's decision that the Safe Harbour self-certification scheme was invalid. Unfortunately, we're not yet in a position of certainty in terms of a replacement for Safe Harbour, despite the recent announcement. And nor are we 100% sure in respect of the long-term viability of other transfer mechanisms. But things have moved on considerably in the last month, and so it's definitely worth taking a look at the recent developments. I also think it's worth having a brief recap and looking at exactly what the issue with the Safe Harbour scheme was, according to the Court of Justice. So just to recap briefly, as Sally said, Safe Harbour was one of the ways in which to achieve the lawful transfer of personal data from the EEA to the USA. Organisations could self-certify that they complied with the requirements under the scheme, which, under a decision of adequacy by the Commission, would then mean they were deemed to be giving adequate protection to EU citizen data. Now, the effectiveness of Safe Harbour, which was loosely overseen by the Department of Commerce and enforced by the Federal Trade Commission, or FTC, was called into question initially in the wake of the Snowden revelations. And it was at that point that the EC began renegotiating Safe Harbour, when the extent to which surveillance of EU data was taking place became apparent. In the meantime, Max Schrems, an Austrian student, had filed a case against Facebook, alleging it was not providing adequate protection of his personal data. And the case went all the way to the Court of Justice of the European Union, which agreed with Mr. Schrems and effectively struck down Safe Harbour in a ruling that came as a shock to many. It's important to take a moment to consider exactly what the CJU's main objections to Safe Harbour were. Primarily, they were firstly the lack of oversight as to whether access to EU data by intelligence agencies was necessary and proportionate, and secondly, the lack of redress for EU citizens for misuse of their personal data. As soon as the CJU decision was published, the EC announced that it was redoubling its efforts to reach a replacement agreement, and the Article 29 Working Party, which is comprised of EU regulators, promised a detailed opinion on the decision and its impact, not just in terms of Safe Harbour, but on other remaining data transfer mechanisms. It also said it would hold off enforcing until the end of January, when it would issue its opinion. In the end, though, the European Commission announced, just in the nick of time, the agreement of the new EU-US Privacy Shield to replace Safe Harbour. This meant that the Article 29 Working Party did not actually give a definitive opinion on data transfers at the end of January, as it had said it would, although it did firmly state that any transfers still happening under Safe Harbour without a replacement mechanism were illegal. Instead, the Working Party has now said it will provide its opinion on the Shield and on other data transfer mechanisms after its next meeting, which is due to take place on the 12th and 13th of April, so that's a big date for us to look out for. In the meantime, though, what exactly is the Privacy Shield? The Commission claims that the Shield addresses both its own concerns and those of the Court of Justice, as set out in the Schrems ruling, in relation to transatlantic personal data transfers. In particular, it claims that the new arrangement offers strong obligations on companies and robust enforcement. The new regime will be more transparent and contain effective supervision mechanisms. There will be tighter conditions for processing and stricter liability provisions for Privacy Shield companies which transfer EU data, whether that's in the US or to third countries. The US Department of Commerce will provide oversight and monitoring of companies to ensure they comply with their commitments, and will also ensure an up-to-date list is maintained and that any companies which do not comply with their obligations are removed from the list. Monitoring will take place when the Department of Commerce receives specific complaints or where there is credible evidence that a company is not complying. Companies' commitments will be legally binding and enforceable by the FTC, which will have the power to impose sanctions for non-compliance. In addition, the EC says that the Privacy Shield will offer clear limits and safeguards with respect to US government access. The Department of Justice and the Office of the Director of National Intelligence have provided the EU with written representations and assurances that access by public authorities for law enforcement, national security, and other public interest purposes will be subject to clear limitations, safeguards, and oversight mechanisms. In addition, there's a commitment that there will be no mass surveillance or indiscriminate gathering of EU personal data. The US will establish a redress mechanism by creating an ombudsman within the Department of State who will be independent from national security services. The ombudsman will follow up on complaints and inform individuals as to whether or not relevant laws have been complied with. And the US says that it will publish these commitments in its Federal Register. The EC further claims that the Privacy Shield will offer protection of EU citizen rights through new redress possibilities. Companies will be required to reply to complaints from individuals within 45 days, and alternative dispute resolution will be available free of charge. EU citizens will also have the option of going to their own data protection authorities, who will work with the FTC to ensure unresolved complaints are investigated and resolved. If that doesn't happen, there will be access to a last resort Privacy Shield panel, which will offer an arbitration mechanism and ensure an enforceable decision. On top of this, there'll be an annual joint review mechanism. This is intended to monitor the functioning of the Privacy Shield and US commitments. It will be conducted by the EC and the US Department of Commerce in association with national intelligence experts from the USA and EU and with EU DPAs. There'll be an annual privacy summit with stakeholders and a public report by the EC to the European Parliament and Council based on the annual review and any other relevant sources of information. And crucially, the Commission may decide to suspend the arrangement if it finds it's not being complied with. So what does this mean for organisations thinking about signing up? There are a number of key requirements for US companies signing up to the Privacy Shield, some of which will be familiar from Safe Harbour and some of which come as an addition. So companies will be required to self-certify annually that they meet their obligations under the Shield. They will also have to comply with privacy principles, which I will talk about in a bit more detail in a minute. But broadly, the privacy principles include providing data subjects with key information about their data, allowing them to opt out where data is to be disclosed to a third party, limiting the process to what is relevant for the purpose, complying with data subject access requests, complying with rules relating to onward transfers of data, keeping personal data secure, providing robust mechanisms to ensure compliance, and providing recourse for EU data subjects. The principles will apply immediately on certification, but for anyone signing up in the first 2 months following the framework's effective date, they will have 9 months in which to bring existing commercial arrangements with third parties into conformity with the accountability for onward transfer principles. So taking a look at some of these principles in more detail, the first one, the information principle, the notice principle. This introduces new information requirements which include the organisation's participation in the Shield scheme with a link to the Privacy Shield list, types of personal data collected, and the entities or subsidiaries of the organisation also adhering to the Privacy Shield principles, the organisation's commitment to be subject to the principles for all personal data received from the EU in reliance on the Privacy Shield, the type and identity of third parties to which it discloses personal information and the reasons or purposes for doing so, the independent dispute resolution body designated to address complaints free of charge, the possibility for the individual data subject to invoke binding arbitration, the requirement to disclose personal information in response to lawful requests by public authorities, including to meet national security requirements. That's quite a long list of information that will have to be given out by anyone signing up. There are also new choice requirements. These oblige organisations to allow individuals to opt out of the disclosure of their personal information to a third party, or the use of their personal information for a purpose that is materially different from the purposes for which it was originally collected or subsequently authorised by the individuals. It's not necessary to provide choice when disclosure is made to a third party that is acting as an agent to perform tasks on behalf of and under the instructions of the organisation. However, a contract is required between the organisation and the agent. In terms of accountability and onward transfer, this principle requires organisations to have entered into mandatory contracts with any other organisations to whom they either transfer data or who process data on behalf of the organisation. Organisations have to enter into a contract with the third-party controller, and the contract will provide that such data can only be processed for limited and specified purposes consistent with the consent provided by the individual, and the recipient will provide the same level of protection as the original data controller provides under the Privacy Shield. To transfer personal data to a third party acting as an agent, organisations have to transfer such data only for limited and specified purposes. They have to ascertain that the agent is obliged to provide at least the same level of privacy protection as is required by the principles, that it will take reasonable and appropriate steps to ensure the agent effectively processes the personal information in a manner consistent with the organisation's obligations under the principles, on notice to take reasonable and appropriate steps to stop and remedy unauthorised transfers, and to provide a summary or a representative copy of the relevant privacy provisions of its contract with that agent to the relevant US enforcement body on request. Other requirements for organisations signing up to the Shield include having to display a privacy policy on their website, replying promptly to any complaints from data subjects within 45 days, and cooperating and complying with European data protection authorities if handling human resources data. So what's the response been to these new requirements? They sound great in theory, but what do the regulators think? The Article 29 Working Party was fairly non-committal in its initial reception of the Privacy Shield announcement, saying, not altogether unreasonably, that it needed to see the details of the proposals before giving its opinion. And as I said earlier, it's now expected to do this after its meeting on the 12th and 13th of April. So what do we think they're going to say? Well, the Commission itself highlights the fact that the scheme will only have longevity if it is taken seriously, not only by companies signing up to it, but also by US enforcement bodies, in particular the FTC and the Department of Commerce, and of course, the US intelligence agencies. The next steps are to consult a committee of member state representatives and for the Working Party to give its opinion before a final decision is made on a finding of adequacy for the Shield. In the meantime, the Commission is expecting the US to begin making preparations to put the new framework in place, particularly in connection with the monitoring mechanisms and the new Ombudsman. So the ball is now firmly in the court of the Article 29 Working Party to provide its opinion on whether the Shield can become a reliable mechanism for data exports to the US. If the Working Party doesn't approve this package, then any advancement of the Shield into an EC adequacy decision will be fruitless because DPAs have the ability to investigate data exports irrespective of a Commission adequacy decision, and that would mean that the current cycle of uncertainty would continue. Approval from the Working Party should not be seen as a formality or a given, but it probably is a prerequisite for the Privacy Shield to become a viable replacement to US safe harbour. While only the Commission has the authority to make adequacy decisions in relation to transfers of personal data, it will be hard-pressed to finalise a credible scheme without the support of the Working Party. Our view here is that while it does step up safe harbour in terms of oversight and enforcement, the Privacy Shield does not successfully address the issue of surveillance of EU data. There remain too many exceptions and exemptions to enable an assessment of proportionality and necessity. And in addition, while progress has been made in terms of redress available to US citizens, this may not go far enough to satisfy regulators. Particular issues are there's no mutual right to enforcement of the Privacy Shield arrangement under international public law. If each side considers that the other is failing in its commitments, it can only discontinue its commitment to the arrangement. The CJEU could therefore invalidate the Privacy Shield arrangement just as it did with Safe Harbour. However, in relation to each jurisdiction, agencies and courts will be bound by commitments. The US courts will enforce the promises made by a company pursuant to the Privacy Shield if the Federal Trade Commission pursues a breach of the Privacy Shield arrangement. And the European Commission will certainly be looking to see active enforcement. Any protections any protections that are given under the Privacy Shield are subject to anything necessary to meet national security, public interest, or law enforcement requirements in the US. And these exceptions remain unclear and subjective and are extremely wide-ranging. The national security exemptions include detecting and countering certain activities of foreign powers, counter-terrorism, counter-proliferation, cybersecurity. I mean, that's a very broad term. Detecting and countering threats to US or allied armed forces, and combating transnational criminal threats, including sanctions evasion. So we can see really there really is a question mark over whether the Commission will have any ability to assess necessity and proportionality in terms of the activities of the intelligence agencies and their access or potential access to EU citizen data. Another issue is the concept of the legal ombudsman who's going to handle complaints relating to government access to data. Now, the Ombudsman won't have to confirm or deny whether the individual has been a target of surveillance, nor will they have to confirm to the individual the specific remedy that was applied if there was found to be a breach of the commitments by the US government. There are also considerable questions over the impartiality of the legal ombudsperson. The ombudsperson is supposedly an independent post, but it's actually going to be part of the Federal Trade Commission, which itself is part of the US State Department. So the Ombudsman will report directly to the Secretary of State, and that does call into question the ability to remain independent. The Hamburg Data Protection Regulator, who takes a notoriously strict approach, has already said that the Court of Justice is unlikely to uphold the Privacy Shield if it's challenged before them, and it's almost certain that it will be challenged if it's adopted in its current form. You can practically hear Max Schrems preparing his papers now. Having said this, political pressure may result in the Working Party hedging its bets in April. It's possible that it will give provisional approval to the Privacy Shield, saying that it will need time to assess how it is working before making a final decision. But even if the Shield does go ahead, it's most unlikely to close the issue of EU-US data transfers, I'm afraid. So where are we at the moment right now? In the wake of the announcement of the Privacy Shield, the UK's ICO has updated his guidance on transatlantic data transfers following the announcement, and he does take a markedly more measured approach than the Article 29 Working Party. The ICO says that Safe Harbour can actually still be seen as providing a measure of protection for data transferred from the EU to the USA, but businesses should be aware that the certainty of an adequacy decision of the Commission has now been removed, and they should make their own assessment of risk to compliance. The ICO also reminds UK businesses that they are not required to rely on Commission decisions of adequacy, but can make their own adequacy assessments. Essentially, the ICO is still advocating a wait-and-see approach, saying that while it will consider individual complaints, it is sticking to its published enforcement policy. The ICO recognises that legal certainty is still unavailable and appears to be taking a pragmatic stance, emphasising the need to consider transfers carefully in terms of the risks posed to individuals. It's worth noting, however, that other European data protection authorities are taking a different approach. Although we have not yet seen active enforcement measures, the French DPA, the CNIL, has already fired a warning shot across the bows of Facebook, and we expect this attitude to continue. So pending an adequacy decision of the Privacy Shield, the situation remains the same for organisations transferring personal data to the USA. Binding corporate rules for intra-group transfers and model contract clauses remain valid transfer mechanisms, and I'm going to hand you over to Sally and Lucy to discuss these in more detail.
Thank you, Debbie. So before we have the confirmation from the European regulators on the Privacy Shield, and in the absence of Safe Harbour, we are left with that compliance gap. And more often than not, across Europe, such gap is filled with the model clauses, which are, as Debbie mentioned, for the time being at least, an approved solution to demonstrate that adequate protection is afforded to data transfers to the US, and all other third countries. In the wake of the Safe Harbour decision, it's likely that you will have been asked by some of your customers, and that you may have asked the same question of your suppliers: how is my data transferred from the EEA to the US protected now? Just swiftly followed with, we need to sign model clauses with you. So what are the model clauses? How do they work? And are there any issues in using them? Current data protection law allows for the European Commission to recognise standard contractual clauses, known as model clauses, as offering adequate safeguards to personal data transferred outside of the EEA to a third country. Model clauses requires both the data exporter, who is located in the EEA, and the data importer, that is based outside the EEA, to comply with certain obligations to ensure such data transferred from the exporter to the importer is adequately protected so that the rights and freedoms of data subjects whose data it is that is transferred are safeguarded. There are two types of model clauses: controller-to-controller model clauses, where the exporter and importer are both data controllers, and controller-to-processor model clauses, where the data exporter is a data controller and the data importer is a data processor. To rely on the model clauses as providing adequate protection, they should be unamended. Amending the clauses in any way can create issues in demonstrating to regulators that adequacy is still provided. Therefore, in practice, the model clauses should not be amended. Let's start by running through the controller clauses quickly. There are actually two versions of these clauses in existence. The 2001 clauses were updated in 2004 to provide a more business-friendly version, and generally it's the second version that is used more widely now. Controller-to-controller model clauses are used where one company transfers data to another company, and each company will use the data transferred for their own purposes. Often you will see these used within multinational companies, where each company within the same group will use the data transferred from the European companies to carry out various functions to serve their own individual interests for their own purposes. Some difference between the 2004 and 2001 clauses include the fact that liability under the revised 2004 clauses was amended so that a data subject can only claim for actual damage suffered and only against the party that has actually caused damage, rather than joint and several responsibility suffered, which was under the 2001 clauses. Further, under the 2004 clauses, the data exporter does not have to respond to the data subject and authority inquiries if the parties have agreed that the data importer will respond, which often involves less time and cost. The controller-to-controller clauses include three parts: the model clauses themselves, Annex A, which contain the data protection principles, and Annex B, which is a description of the transfer. There are also some illustrative commercial clauses, which are optional, to illustrate provisions on indemnities, dispute resolution, allocation of costs, and additional termination provisions. Annex B should be completed and approved by both parties. Secondly, you have the controller-to-processor clauses, which act in very much the same way but cover a different activity. That being, where a company, the data exporter and data controller, transfers data to another company, the data importer and data processor, who is processing the data on behalf of the data controller and in accordance with the data controller's instructions. Under these clauses, the party causing the breach will be held liable for the breach. The data subject is a third-party beneficiary to the clauses and can enforce applicable provisions against the offending party. However, it is the data controller, that's data exporter, that will always retain responsibility for any damage that a data subject may suffer as a result of any breach of the obligations by any party or sub-processor. The only way in which a data importer would assume this responsibility is if the data controller factually disappeared, which is a relatively unlikely, although not impossible, scenario. The sub-processor can similarly only become liable where the data importer factually disappears. It's therefore understandable that data controllers review the recipients of their data carefully. Importantly, these clauses also account for onward transfers of data, so that if the non-EEA data importer, the processor, engages a sub-processor, it is required to contractually slow down the obligations which they sign up to, so the rights of the data subject are adequately protected. Similarly, these clauses are made up of three parts: the model clauses themselves, Appendix 1, which is the description of the transfer, and Appendix 2, which describes the technical and organizational measures, often simply referred to as a security schedule. It is useful for the data importer to complete the schedules, which should be assessed by the data exporter, so that from a compliance perspective, the data exporter can be sure they are satisfied that the description is accurate and that the measures in place are satisfactory. As for controller-to-controller clauses, there is an illustrative indemnification clause which is optional to include. One of the clear benefits of the model clauses is that they are relatively quick to put in place, save for any local filing requirements, ensuring the clauses are unamended, and data exporters being satisfied that the data importer will live up to their obligations under the clauses. It's also cost efficient. The level of detail to be provided in the description of the transfer or security schedule need not be a full sweep of all policies and procedures, so these are not made public. In some instances, further time and money savings may be made, and it's possible to reuse the same form model clause agreement with multiple customers or suppliers. For example, we have seen some big US service providers publish online their model clause data processing addendums for their various customers. However, there are some key issues to be aware of. As mentioned previously, in order to rely on any steps of the model clauses as providing adequate protection to personal data transferred outside of the EEA, they should be unamended. Although it's possible to add an additional party, and the model clauses can be incorporated into other contracts, such as data processing agreements, intragroup agreements, and data processing addendums, the latter of which we have seen issued by many US suppliers in order to address their compliance gap created by the invalidation of the safe harbor scheme. Incorporating the clauses in these ways is fine, so long as nothing in the wider agreement or additional commercial clauses alters the effect of the model clauses. To preserve the status of the model clauses, companies have tended to use a conflict clause to state that in the event of conflict, the model clauses will always prevail over any other provisions in the data processing addendum or intragroup agreement, for example, to help evidence that the intention of the parties ultimately is not to amend the model clauses in any way. The provisions of the model clauses and obligations created by them must always remain clear and legally binding. If this is not the case, or if any of the wording of the actual model clauses is changed in any way, such clauses are not deemed to provide adequate protection. Currently, as European data protection law is established as a directive, each member state implemented its own national act to give the directive effect in their relevant jurisdictions. The effect of this has been that data protection law across Europe is somewhat of a patchwork, and this is reflected in requirements surrounding model clause contracts too. In the UK, so long as the model clauses are used or unamended, it's possible to rely on these ensuring adequate protection, and such contracts do not need to be filed with the Information Commissioner's Office, although they might ask to see the contract. However, across the EEA there are different requirements, and in some European jurisdictions, even where model clause contracts are unamended, they must be lodged with the local regulators, and in some countries, authorization or pre-approval of such contracts is also needed. During such processes, contracts using model clauses may come under the scrutiny of the regulator. Even those regulators that don't see model clause contracts, as evidenced recently by German data protection authorities, who don't always require model contracts to be filed, may scrutinize the use of model clauses in some circumstances. Therefore, whilst the message from the ICO in the UK has been don't panic, companies must analyse and look to address any compliance gap created in the post-safe harbour world. For those companies trading across Europe, this is especially important as they may have to deal with further regulatory requirements. As is often the case with law, it can be slow to adapt and reflect the pace of technological change and development. There are aspects of the model clauses which do not seem to fit comfortably or indeed appear practical. For example, the wide-reaching audit rights. Imagine if, in reality, if each data exporter exercised these, enshrining the rights of the data subjects, consider if each data subject enforced these rights, and requirements around engaging sub-processors. How is consent from each data exporter obtained? Do you keep records of this consent in practice? At the same at the time the model clauses were conceived, if you imagine a data processing arrangement to be similar to the one on the slide, whereby there is a discrete data transfer from one company to another, data exporter based in Europe, data importer based in a third country, for example the US, you can see how the model clauses would work straightforwardly. However, in the interconnected international cloud-based world, the model clauses can be an imperfect solution. And companies must consider data transfers carefully to ascertain the point at which data is transferred and ensure this is compliant. There can be a conceptual disconnect between implementing model clauses to address the compliance gap as is required and the reality of the point at which the data is actually transferred. The Article 29 Working Party and individual regulators have issued guidance over the years on how model clauses can be applied in the more complicated situations. One scenario which showcases the model clauses as an imperfect solution is where an EEA-based data controller engages an EEA-based processor who then engages a US service provider, for example, as you can see demonstrated on the slide, who then may go on to engage a further sub-processor. Article 29 has published an FAQ document to address some of the issues raised in this situation and offers some solutions, including direct contracts to be signed between the EEA-based controller and the non-EE-based processor, whereby the data controller signs as data exporter and the sub-processor signs as data importer. However, query whether a data sub-processor would be willing to do this, given that they have no idea, perhaps in reality, that the data controller's information is actually processed by them. Secondly, Article 29 Working Party suggests that another option could be a clear mandate from the EEA-based controller to the EEA-based processor in order to use the model clauses in their name and on their behalf with the sub-processor, which companies have approached by signing an addendum with their EEA-based controllers, stating that they have in turn executed the model clauses with their non-EEA-based sub-processor. And finally, ad hoc contracts that provide that the EEA-based controller and the non-EEA-based sub-processor will be bound by the same duties and rules of liability as in the model clauses, which each member state can then assess. It's important to note that this guidance was issued by the Article 29 Working Party in 2010, and in the 6 years that have passed since then, we have seen a continued pace of technological change and advancement. These FAQs are not legally binding nor exhaustive, but do seek to provide options and guidance to companies dealing with the global marketplace today. Any guidance issued by local data protection authorities to help understand how to apply model clauses in these increasingly complex webs of transfers is likely to prove helpful, although in many cases seeking specific legal advice on the transfers will be appropriate. Further, across Europe, the various options described above offered by the Working Party as solutions may not be recognised in the same way. As mentioned above, in practice we have seen a lot of US-based service providers issue their own data processing addendums containing wraparound text and then appending the model clauses to evidence to their customers how they are helping them be compliant with European data protection law. These data processing addendums often also refer to the customer's underlying data and acknowledge that they may be both a processor in relation to their customer data and sub-processor in relation to their customer's customer data. So where has this got us to today? In terms of EU-US transfers, post-REMS, what we have seen could be described as a model clause frenzy, so that companies are requiring model clauses to be put in place with their customers, suppliers, sub-processors, sub-sub-processors, etc. But are model clauses really a safe option to rely on, or will they suffer the same fate as safe harbour? Given the reasoning of the CJEU in the safe harbour decision, as described by Debbie earlier, it's not impossible to see that the CJEU could apply such logic if the model clauses were challenged in the same way. Further, the question has been raised, has this frenzy of implementing model clauses really served to guarantee the rights and freedoms of data subjects, or has it just initiated a wide-scale papering exercise? Some German data protection authorities have queried whether US-based importers can even comply with the obligations imposed on them under the model clauses, given their need to comply with US law. In light of this, everyone has looked to the European regulators for advice. And as Debbie mentioned, the Article 29 Working Party had been expected to assess the impact of the CJEU ruling on the other data transfers by the 31st of January. However, the announcement of the EU-US Privacy Shield changed the programme. We're now expecting for this update later next month. So what does this mean for you? Model clauses are a legitimate mechanism to transfer personal data to the US. When used as part of an intra-group agreement, they can cover a wide range of data, and the IDAs can look to incorporate worldwide privacy compliance too, and as such can be party to the embryonic stages of a company aiming for BCRs, which Sally will discuss next, although BCRs too are not also always appropriate. Nevertheless, model clauses remain the most pragmatic option, and it's hard to imagine a world in which the model clauses did not exist, even if they are an imperfect solution at times. I'll now hand over to Sally to discuss BCRs.
Thanks, Lucy. So, Lucy's spoken about EC standard contractual transfer clauses, and these have certainly been seen as a relatively quick and cheap and flexible way for the parties to transfer personal data out of the EEA to implement bilateral protections for transfers of specific sets of personal data, as well as being capable of being integrated as part of the wider commercial agreement. For example, from the perspective of corporate group and intra-group transfers of employee or CRM data, transfer contracts work well, where the types of data flows and the spread of transfers are quite discrete. They do not work, however, where the spread of the organisation or the scale of different types of recipient or of data involved would make the use of contracts for each transfer a logistical and compliance nightmare. In these situations, an alternative solution is needed, and this is where binding corporate rules step in, or indeed binding corporate processor rules, if we're talking about a corporate group providing processor services to multiple clients, such as a cloud hosting provider. If you're unfamiliar with binding corporate rules or BCRs, these are essentially a set of legally binding, consistent internal rules and standards for the protection of personal data that a corporate group adopts across its global organisation in relation to transfers to those group entities in countries that otherwise don't offer an adequate level of protection. So BCRs have a lot of advantages over contracts in that there is some flexibility around the form that these internal rules, standards and codes of conduct take, meaning that they can be tailored in a way that reflects both the culture and the structure of the organisation. In addition, the processes of putting in place group-wide binding standards and rules for processing personal data helps with building the framework for an organisation's wider programme of data protection compliance. And in the longer term, this cuts down on the administrative burden of having to look at and manage individual adequacy mechanisms for quite potentially complex and widespread international data flows. So to reach that effectively data transfer nirvana, however, it takes some considerable time and effort and cost. And that effort has to be expended. There has to be a sort of real driver for that. And until recently, that effort and cost perhaps tended to put off organisations, perhaps with all but the most complex data transfers being considered for a BCR solution. And many instead would look to implement a sort of a more immediate contractual approach. However, this BCR situation has gradually been evolving and changing as organisations more commonly operate in globalised markets with a a larger market footprint, and also due to a growing recognition of the wider benefits of organising a compliance framework for the group, particularly in the case of the more recently adopted binding corporate rules for processes schemes, where you also get the added kudos of having an approved BCR status that can give an organisation an edge over its competitors, clearly sending out a message to potential clients that the processor group can offer a safe and a legally recognised set of standards in relation to its handling across its group of exported client data. To date, 80 organisations are now officially recognised as having a finalised BCR scheme in place, where the approval process for that BCR is deemed as closed, and just under 10 organisations have achieved the same status for the more recently implemented binding corporate processor rules scheme. The key stages of the BCR process involve the following. Firstly, Stage 1, which relates to the preparation or scoping of the steps to take. And there are a range of relevant considerations when scoping a BCR, in particular identifying the different types of data involved and mapping the flows, as well as establishing the parties to be covered. But it's also about taking the important step of officially designating the data protection authority that's going to be acting as the lead in reviewing and coordinating the BCR application when it's ready to be submitted with the other selected data protection authorities. This is typically going to be the data protection authority where the organisation has its European headquarters, but there will be other factors that can also be relevant. In most cases, it would be expected that the designation of the data protection authority will flow from having first had some initial preliminary conversations with the likely potential data protection authority, as partly as a courtesy to forewarn them that there's a potential BCR application coming down the line, but also to enable the DPA to appropriately schedule in the application because of the amount of time and effort that their own involvement in that application process can take. That forewarned is forearmed, as it were, in these situations. And it also means that when they're ready to accept that application, it also means that the organisation that's making that application is presenting it at the time, the optimum time, as it were, for the most efficient handling of the application. So moving on from those sort of preliminary scoping and preparation steps, Stage 2 is about drafting. In terms of drafting group-wide policies and standards and processes for compliance and enforcement across a group, these need to be drawn up in a way that reflects the requirements of the various opinions, which I've listed out on the other side of this slide, that have been issued by the collective data protection authorities through the body of the Article 29 Working Party. And where these policies and standards are drafted, they need to be then socialised across the group and internally agreed and formalised. There are then a number of formal application forms that will also need to be completed, and these give information about the applicant and about the BCR scheme and its privacy standards, and they will explain how individuals' rights are respected and how the scheme will be managed and enforced in practice across the group. There needs to be evidence of the practical ways that the organisation ensures that all in the group are going to be aware of the BCR and of their obligations, as well as showing that there are consistent approaches to how complaints are handled and how cooperation with the data protection authorities will take place. And also demonstrating that there will be effective oversight of all those mechanisms through independent audit processes. A unilateral mechanism is then going to be needed by which the compliance by all the affiliates across the group can be declared and that unilateral mechanism should be coordinated and provided for by the parent company. So depending on how advanced an organisation's existing compliance framework is, this process of drafting and internal socialising and agreeing of the policy standards and controls can take anything from between 10 months to 2 years. Then we're moving on to stage 3, and this is where the BCR application is submitted to the Data Protection Authority. The Data Protection Authority will review and discuss the BCR with the applicant and may suggest changes. Once the DPA is comfortable with the approach, the application is then shared by way of mutual recognition procedure with other data protection authorities that are relevant to the transfers that will be covered by the BCR scheme, and they will check that material and feed back to the lead DPA with their comments. This cooperation procedure is closed when the countries under mutual recognition have acknowledged the receipt of the BCR, and that those that are not under mutual recognition have recognised that the BCR complies with the requirements that are set out in the Article 29 Working Party materials. And this process of the submission and assessment of the application can take anything up to 12 months. And then we get to stage 4, which is filings. So once the BCR is adopted, the organisation must then, where required by local national laws, get the approval of each of the relevant European DPAs in terms of making a filing where a filing is needed or getting the approved BCR authorised. This sounds like an unnecessary extra piece of work given what's already taken place in terms of the assessment and mutual recognition process. In practice, though, it should just be a formality given what has gone on before, but is necessary to meet the technical requirements of local laws. So, taking all of these 4 stages into account, where an organisation picks the right moment to submit its application and has already got prior, robust and consistent cross-group global controls for data processing, exports, and has a fair wind behind it, then it may not be unheard of for an application to get through stages 2 to 3 with the DPA authorisation within, by say about 12 months. In practice, however, the authorisation stage is more like the jam in a kind of a big sandwich, and across all stages of putting a BCR in place, a business could perhaps more realistically be looking at between 2 and 4 years for the whole process. So it's very much an option for those who are prepared to take a longer-term view for their compliance programs. So where do we stand with BCR at the moment? Well, BCR is still recognised as a valid adequacy mechanism by the Commission, but as with any EC adequacy mechanism, it could, of course, be challenged if, in the context of a specific jurisdiction, the equivalence of protection in practice, as was the case in the US, is considered to be lacking or found wanting in some way. In practice, however, BCR is generally viewed as providing stronger protections than standard contractual clauses and should therefore stand up better to scrutiny in the event of a legal challenge. However, the announcement by certain German DPAs that they would not authorise any standard contracts or BCRs pending the outcome of the wider privacy shield considerations may give organisations some cause for thought, although bearing in mind that German law doesn't proactively require the German DPAs to actually authorise any standard contractual contracts is a moot point. But it may give organisations pause for thought if they are actually at the beginning of that journey. They're thinking of embarking down the path of a BCR. It may in that situation be preference to wait until the picture and the risk of any legal challenge is clearer. although this is not going to deter those, I think, who are already committed to and some way down the application process. So I now want to, as in the normal course of business, to offer you up some polling questions, the answers to which will help inform other listeners today about where the lie of the land is in terms of people's views on different issues to do with transfers, the Privacy Shield, and where they think the direction of travel is headed. So the first of these questions is, have you now implemented alternative solutions for transfers to or by your organisation that were formerly made under Safe Harbour? If the answer is yes, then that's A. If your implementation process is still ongoing, you're still assessing client-vendor agreements, then please select B. And if you're still waiting on the outcome of the Privacy Shield and you're not implementing alternative solutions in the interim, then the answer is C. The second question is, will you be willing to adopt or allow for transfers by your organisation to the US under the Privacy Shield if and when it is finalised? If the answer is yes, you are willing to allow for transfers to take place under a Privacy Shield scheme, then the answer is A. If the decision, however, is no, that you're actually going to stick with relying on another approach going ahead, or C, if you're unsure and you're going to keep this issue under review. And then the third question, what alternative approaches are or do you have most confidence in for EU and US transfers? Do you feel that a finalised Privacy Shield is the way ahead? Do you think that no, the answer is model clauses or binding corporate rules would be C? Or D, are you looking for some other alternative approach such as consent? Or are you in fact going to look at none of those methods and in fact are going to try and look to keep your data in Europe? So give you a moment or so to ponder those questions and provide your responses. And while you are doing that, and we're just waiting for the answers to come through, we'll take a look at some of the many questions that have come through. So we have one question here. How does the Privacy Shield link to the general data protection regulation, and will it be overtaken by events? And I think there's a couple of points to make here about the relationship between the Privacy Shield and the general data protection regulation. Firstly, I'd say that it does link to the extent that the general data protection regulation recognises that mechanisms that are based on an existing valid adequacy decision under, such as, for example, standard contractual clauses, and to the extent that the Privacy Shield is agreed upon, then those valid mechanisms will carry forward under the general data protection regulation. To the extent that, the second point I'd make, that the general data protection regulation, as a consequence of the Schrems case, does include a last-minute adjustment that specifies what the criteria are for a valid European Commission decision should be. Because one of the points that came out of the Court of Justice of the European Union's decision was the lack of a defined criteria by which an adequacy decision can be relied upon. So that now, there's sort of a menu, as it were, for an adequacy decision. What are the core components of an adequacy decision? And clearly, those components will have influenced the discussions that have taken place for the putting together of the Privacy Shield proposal. So to the extent that all can get comfortable with the Privacy Shield, and it does get finalised and agreed upon by all parties, then to the extent that it is recognised and there's an adequacy decision that applies to it, then it will carry over with all other valid recognised mechanisms in the same way under the regulation. So we've got all of the results back to the polling questions. Let's see. So first question, have you now implemented alternative solutions for transfers? Yes, 27% have answered yes to that question. 52% of you, however, are still going through that process of assessing your client and your vendor agreement. So the majority of you are still on that journey to catch up with your agreements and your client-vendor relationship. And 20% of you have decided not to implement an alternative mechanism and are still waiting on the privacy shield. Then the second question, will you be willing to adopt or allow for transfers by your organisation to the US under the privacy shield if and when it's finalised? So here we have 55% of you are unsure and are going to keep the issue under review. So that's the majority of you are still hesitant about whether the privacy shield is going to be a reliable alternative solution. 32% of you, however, say yes, you would be willing to adopt privacy shield if and when it's finalised, and 11% have said no, they've actually decided that they're going to continue to rely on another mechanism going forward. And then the third question, what alternative approaches are or do you have most confidence in for EU-US transfers? And here we have 30% have argued that, have indicated that a finalised privacy shield would be an alternative solution that they have confidence in. 36% have indicated that they would have more confidence in model clauses. 11% are showing that they would have most confidence in a binding corporate rules approach, and 9% are looking to rely on another mechanism such as consent, and 2% have decided that no alternative approach is going to be considered and they're going to keep the data in Europe. We do have plenty of other questions that have come through, but I'm conscious that we are running out of time today and that we have sort of exceeded our allocated slot. So we will be looking at those questions separately outside of the webinar, and we'll follow up with delegates who have raised a question that outside the webinar and come back to you with our feedback on that. Just to let you know, there was also a couple of dates for your diary looking forward. So coming up on April 14th, we will be hosting a breakfast seminar where we will be joined by Gerald Ferguson, who's partner at Baker Hostetler's data protection team in New York, and we might be looking at issues to do with the Apple encryption enforcement case in the States. We'll also be revisiting the progress of the Privacy Shield, because we should have some more update on the development and the feedback from the Article 29 Working Party by that date. So that should be an interesting breakfast session on the 14th of April, and there are details about that on our webinar, on our website. And then we also have our next webinar, which is scheduled for April the 19th, and we are going to be looking at the issues around the regulation. I think we're going to be focusing first on issues to do with establishment. So with those dates for your diary, I would like to thank you very much for joining us today. My apologies for the slight stickiness of some of our slides, but hopefully we caught up with you. And we look forward to you joining us in the future. Thank you. Goodbye.
Ladies and gentlemen, that does conclude today's presentation. We'd like to thank you once again for your time today, and you may now disconnect.